Good afternoon. I am attorney Robert Broadie, and I want to welcome you to our first episode of Testimonial Tuesday, where we will take a grab bag of questions and take one of them and attempt to give you a good, competent legal answer to that question. I want to first thank everyone who has been supporting our episodes of Testimonial Tuesday by posting your questions to our Facebook page at Carolina Legal Solutions at facebook.com or on our actual website at carolinalegalsolutions.com. So our first question comes from a young man by the name of Gregory. He has posted a question that he would like for us to answer for him, and this question is as follows. He says, "Dear Mr. Broadie, I have been charged with a crime of common law robbery, and I would like to know what type of prison time will I be facing if I am convicted." Well, Gregory, once again, thanks for submitting that question. There are a lot of factors that go into determining what an individual's sentence would be based upon the crime. Now, one of the things that we like to do at Carolina Legal Solutions is before we ascertain whether a person is actually going to plead guilty or go to trial, we'd like to first assess the facts and assess all the elements of the cases when they come into our office. So before we get to what the actual prison sentences would be, let's look exactly at the elements of common law robbery. Now, what I have here is a older version of the North Carolina Crimes Guideline book, and this book has just about every criminal statute in the state of North Carolina in it. And one of the things that we would do is go and find common law robbery. Well, common law robbery can be found in two places. One, in the section of common law robbery, and it is found here at this section, or we can go to robbery and find it under robbery under common law on page 235. Okay, so once we determine what the statute is, or of course you could just go to the computer, Google common law robbery and for North Carolina, and the statute will come up and it'll tell you all the elements that have to be met in order for a person to be convicted of that crime. So in North Carolina, a person is guilty of common law robbery if the person commits a larceny from the person or from the presence of another person by violence or intimidation. So what that means is that all three of those elements must be met in order for a person to be convicted of common law robbery. The person must commit a larceny, which is the taking of a thing with the intent of depriving that person of that thing permanently from a person or from the person's presence by violence or intimidation. In North Carolina, common law robbery is a Class G felony, which we'll get to once we start talking about the guidelines. So a person who is guilty of common law robbery can be determined to be guilty in two ways. One, a person can enter a plea of guilty, a plea of no contest, where the judge may consider them to be guilty despite the fact that they do not admit that they are guilty, or by going to trial. And if they go to trial and the prosecutor is successful in proving beyond a reasonable doubt that the person is guilty, then the jury will adjudicate them as being guilty. Well, once that element is met, or once a person has been found guilty, then you go to the sentencing phase, in which speaks to Gregory's question. In North Carolina, we have what's called structured sentencing. In structured sentencing, we use a punishment chart. This chart is essentially a matrix which defines where an individual is placed in this grid to be sentenced. So, for the sake of this example, we've illustrated that common law robbery is a Class G felony, but felonies in North Carolina are given an alphabetical category, all the way from A all the way down to I. And the letter essentially illustrates the seriousness of the crime. So Class A felony in this instance will be akin to first-degree murder. Okay, and the Class I, which is the least serious felony in the state of North Carolina, will be something like felony possession of marijuana. That would be something that would be a Class I felony. So What we first would do is determine that common law robbery is a class G. So we go down and you'll see it's the third from the bottom, which means that it's not that serious of a felony. Now, once we determine what class the felony is, in this context is a class G for common law robbery, we then will have to go to the person's record, their criminal history. Their criminal history determines what criminal history level they are. Now, in our matrix in the sentencing chart, the criminal history is categorized as a 1, 2, 3, 4, 5, or 6. So we will go across and determine what the individual's criminal history is. In doing that, what we typically do is look at a person's criminal record, and certain crimes of conviction are given certain points. In the felony context, class 1 misdemeanors and above are counted for points. And in the context of felonies, depending upon the level of a previous conviction, you're given points for those felonies. So, determining a person's sentence is not as simple as just determining whether they're guilty or innocent. What you have to first do is determine what class the crime is and what category the individual's record is. So, if Gregory has not had any previous convictions for any previous crimes, he will be categorized as a level 1. In our example, a class G level 1 will be in the very first block. Okay? It will be in the very first grid, which is a I/A grid. Now, what that IA means is that the judge is given some degree of discretion in what we have here as structured sentencing. The IA is giving the judge discretion to give the defendant an intermediary punishment, which we'll talk about in a minute, or an active punishment, which is active term of imprisonment. So in this case, if Gregory is a is a criminal history category 1 for a class G felony, he can get an intermediary punishment, or he can actually get an active sentence. So when we're looking at this, and if Gregory was sitting in my office, I would ask him a few questions, and I would say, "Hey, Gregory, what is your criminal history like? Can you tell me if you've been committed? Have you ever committed any other crimes? Have you ever been convicted of any other crimes?" And the answers to his questions will give me some type of idea of where he will fall in that criminal history. Then I will ascertain whether the elements of this particular crime will have him in what we call the aggravated range, the presumptive range, or the mitigated range. Every grid here is going to have 3 different sections where the judge can find discretionary grounds to sentence a person. So in our particular example, the aggravated range is 13 to 16 months, the mitigated range is 8 to 10 months, and the presumptive range is 10 to 13 months. So if a person has mitigating factors, like he cooperated early at the early stages of the investigation, or he has a strong family support system in the community, or if he provides substantial income and support for his family. Those are things that are mitigating factors that we may be able to argue to a judge for a judge to sentence him beginning in the mitigated range. Now, on the other hand, if the prosecutor argues that there are some aggravating factors, maybe that the individual took or abused a position of trust, or maybe the individual took and abused a person who was handicapped, or any other aggravating factors pursuant to the statute, that the prosecutor will argue, and he may successfully argue for an individual to be sentenced starting at the high end or the aggravated range of the statute. If there's no mitigating or no aggravating factors, the judge will normally sentence a person in what's called the presumptive range. In this particular instance, it is 10 to 13 months. Now, what does that 10 to 13 months mean? It doesn't necessarily mean that the judge will sentence him to 10 to 13 months. That means that the judge can start the sentence at 10, 11, 12, or 13 months. So, in North Carolina, if you have a sentence that is anything from an I to an A, you get this felony chart, and you look at it. And in our particular case, if a judge was starting a sentence at the range of 10 months, we will look on the back side of the guideline range, and we'll see that if a sentence is starting at 10 months, the judge will issue that sentence from 10 to 21 months. If it starts at 11 months, it'll be 11 to 23 months. If it goes to 12 months, 12 to 24 months, or 13 months, it'll go all the way from 13 to 25 months. Now, the reason why the judge does that is because in North Carolina, as I stated, we're under a structured sentencing statute, and there's no parole. But what we do have is what's called post-supervised release. Now, every sentence in felony sentencing is given a 9 months post-supervised release. So if we get a sentence that goes from 10 to 21 months, the last 9 months of that sentence is served on post-supervision release. Okay? So what that would essentially be would be 10 to 12 months. There will be a 10 to 12 month sentence. 9 months of it will be supervised release, making it a total of 10 to 21 months. Now, does that mean that the individual has to necessarily go to prison for 10 months? No, because as we stated, the judge has discretion in the IA box where he can give that person what's called an intermediary punishment. An intermediary punishment is a punishment that has an intermediary sanction. He may give the individual what's called a split sentence, give him a few months, few weeks, or even a few days in jail, and send him out on probation. He may give the person what's called intensive probation, where he may have an extended amount of curfew, community service, or even electronic monitoring, or even home confinement. The judge can give those types of sentences in lieu or in addition to probation as intermediary punishment. Or, of course, if the young man is in the IA, the A portion of it, the judge could actually sentence him to that term of imprisonment to be all served at the Department of Corrections. So, in answering Gregory's question, it is not as simple as saying that you have been convicted of a crime or you plead guilty of a crime, what is my sentence going to be? There are a number of factors that go into calculating what a person's potential sentence will be in committing a crime in North Carolina under the North Carolina structured sentencing. So if you have a situation where you think that you may be pleading guilty or the circumstances are such that you may be found guilty of a crime and you're concerned about what your sentence will be, have your attorney sit down with you and go over fully what the North Carolina sentencing structure is and what the guidelines say about what potential sentences are. Also, make sure you talk to your attorney about what possible mitigating factors you may submit in order for him to get you a sentence in the mitigated range. And of course, if you do not have legal representation, we always encourage you to find legal representation to help you navigate the waters of criminal court. If we can be of any help to you at Carolina Legal Solutions, feel free to give us a call, 885-1-LAW. Thank you.